Although I'm not a licensed estate attorney and have my limitations, I understand the importance of estate planning and going beyond the legal language. You already have an estate plan, but it's up to you to ensure it's intentionally aligned with your personal wishes. The primary estate documents that are important to draft and review are last wills, powers of attorney, advanced medical directives, HIPAA authorizations, and trust agreements. There are multiple resources available to draft the estate documents we'll preview today, and these three primary options should consider the complexity of your financial situation and family dynamics. The first option, many workers have access to a group legal plan available through their employee benefits. You can discover if this is available for you by reviewing your employee benefits handbook or contacting your HR administrator. Elective enrollment in a group legal plan typically costs around $200 per year, and it often provides an online estate planning portal or access to an attorney to review those templates. Another way, separate from a group legal plan, is using an online estate planning portal that walks you through the documents step by step using your state-specific template. I've included links to some of those options below. And the third option is hiring an estate attorney within your state, which is often the most appropriate option for families with complex relationships, beneficiaries with special needs, illiquid assets, or estate and gift tax concerns. Deciding between these options should consider the complexity of your family dynamics, financial situation, and multi-generational objectives. Here is an example of an estate document summary. As you scan through your existing documents, you can fill out this downloadable template, and if you haven't drafted them yet, this template may help to guide your thought process and deeper family conversations. To bring this all to life, pun intended, let's review some estate document examples together, starting with the last will and testament. As an important note, please do not use these examples as templates to draft your actual documents. The first thing we find out is whose will this is, Susan B. Sampleton, and the state in which it was drafted, Texas. You should ensure your estate documents are in full compliance with your state of residence, also called your domicile, including how your state treats marital property and the variance of the probate process. Moving on, we see that Susan's will was created when she and Stephen were married. Your estate documents and your beneficiary designations should be revisited anytime there is a birth, marriage, divorce, death, or change in your family relationships or charitable intentions. The will includes what's called a bequest of tangible property and real property. These sections describe who gets what, and it's common for the surviving spouse, surviving dependents, or siblings to be listed here. Other specific bequests may include charitable gifts, as we notice Susan would like $75,000 to be given to her favorite charity, Save the Bears. I've also met families who want to provide financial support to their friends or workers, such as live-in nannies, often with separate letters of instruction. This is a good time to reiterate that a lot of estate planning considerations happen without regard for the will, including beneficiary designations and account titling. Retirement plans, education savings accounts, and insurance policies are individually owned but can list primary and contingent beneficiaries, and non-retirement assets and accounts can be titled joint tenancy with right of survivorship, JTWROS, tenancy by the entirety for married couples, TE, payable or transfer on death, POD or TOD, or titled to a trust. Whether passing by beneficiary or account title, these assets pass directly to whoever is listed rather than referencing the last will, which is really the document that says what happens with the residuary estate, meaning whatever else remains. Keep in mind that every state has its own rules. Please do not trust my general information for where you live. Back to the example will, the residuary estate, also called the residue, that remains after all specific gifts have been made, is also given to her husband Steve, and if Steve predeceases her, equally divided between their children. If their kids are still minors upon both of their deaths, the estate property will be held for their benefit either in a custodial account called an UTMA until they reach the age of majority in their state, or in trust with a named trustee for their benefit to pay for their health, education, maintenance, and support, also called HIMSS. This is called the ability to control from the grave, with many parents wanting their children to inherit the estate at certain ages rather than the age of majority, 18 or 21. Although we often think of a will as something that answers who gets what, it also says who does what. In this example, Susan has appointed her sister-in-law, Eggs Porter, to be the guardian of any minor children in the case of both parents passing. This is an important conversation to have as a family, discovering which characteristics would make someone the ideal appointment to care for your children. And before you list a designated guardian, please ask them for permission in advance. This will also includes a pet provision, designating $5,000 for the future care of their pets if Susan and Steve both die. Have you thought about who might care for your pets if you were to pass away? It's a sad thought, but it's an important consideration. Another example of who does what is the appointment of the independent executor, the personal representative who's appointed to be responsible for carrying out the terms of your will and overseeing the administration of your estate. This is a critical role, and it's important to ensure this appointment is intentional, with the appointed person being reliable and trustworthy. As it is here, the primary appointment is usually their spouse if married, and Susan has listed her brother Ham as a successor if Steve predeceases her or is unable to serve. Some people list their adult children or siblings here. And following is the list of powers that executor is authorized to perform. If enforceable, a will may include a no contest clause that states anyone who tries to dispute the will would be disinherited, discouraging disappointed heirs from challenging its validity or intent. The survivorship period states that beneficiaries cannot inherit unless they live for a specific amount of time beyond the decedent, often 30 or 60 days. Some states have survivorship requirements due to the risk of near simultaneous death. And lastly, but so important, you'll want to ensure your estate documents have actually been initialed and signed by all required parties and notarized, including the self-proving affidavit. We now move to the durable power of attorney, which is to be used during life rather than upon death. It includes the principal's name and the agent, attorney in fact, appointed to manage financial affairs on their behalf as a fiduciary, either immediately or upon incapacity. In this case, Susan selected her husband Steve, which is the most common when married. The next section includes the powers that would be granted to the agent under the POA, power of attorney. As mentioned, the POA states whether it is effective immediately upon signing or only in the event of the principal's incapacity. When my wife and I bought our house, she couldn't make it to the titling company office that day, but I was able to act as agent and sign on her behalf since we had an immediate POA on file. Of course, you'd only want someone to have the immediate right to act if you absolutely trust them. Susan also listed successor agents, her brother Ham and his wife Eggs, who was also her appointed successor executor in the will. The medical power of attorney and advance directive to physicians are next, and they're often combined documents. Similar to the durable power of attorney for financial matters, this POA appoints an agent, also called a proxy, to make decisions about the principal's medical care when they're unable to speak for themselves. Susan appointed her husband Steve, and her brother was named as alternate agent. The locations of the original documents and signed copies are also included here, one at each house. It's important that all appointed agents have copies of these signed documents to ensure they can actually be used when they're needed. And the advance directive states wishes about medical care in the event of a terminal or irreversible condition, becoming effective when an attending physician certifies that condition in writing. In this case, Susan has elected to withhold life-sustaining treatment. A HIPAA authorization to release medical information to others may also be included. To finish off these documents, here's an example of a revocable living trust agreement. We see the trust name, the trust grantors and trustees, Susan and Steve, the successor trustees, Ham, then Egg Porter, the trustees' specified powers, and the beneficiaries of the trust, their kids who will inherit the trust property at age 25. Since a trust comes into being when it is funded, it is customary to quickly establish its existence by retitling various assets in the name of the trust, such as real estate, bank accounts, and other taxable assets that prefer additional direction, that ability to control from the grave, and privacy outside of the will and the public probate process. Once your estate documents are signed and in place, you can summarize them all onto one page and provide a copy to the designated executors and agents, along with copies of the documents themselves. Many families prefer to keep the original documents in a safe deposit box or at their estate attorney's office. And a final reminder, check your account titling and beneficiaries on all retirement plans, bank and investment accounts, and life insurance policies.